Before we start, here our disclaimer: the information provided in this presentation is intended for educational and informational purposes only. It does not constitute legal advice and should not be relied upon as such. Every legal situation is unique and should be discussed with a qualified legal professional. The views and interpretations expressed in this presentation are my own and do not necessarily represent the views of any legal institution or authority. Now let's proceed. Greetings everyone. Today, I'd like to discuss a landmark case in English contract law, Taylor v. Caldwell, which established the legal principle of frustration of contract. This principle applies when an unforeseen event makes it impossible to fulfill the terms of a contract. In this case, Mr. Taylor and Mr. Lewis had contracted with Mr. Caldwell and Bishop to rent their music hall for 4 concerts. They had planned extravagant entertainments, including performances by Sims Reeves, a military and quadrille band, and various other entertainments. However, a week before the first concert, the music hall burned down, an event that was beyond anyone's control. Taylor and Lewis sued Caldwell and Bishop for breach of contract, claiming that the owners failed to rent out the music hall to them. The case was heard in the Court of Queen's Bench, which had to decide whether the contract had been frustrated by the destruction of the music hall. The court held that the contract was indeed frustrated. The destruction of the music hall was an unforeseen event that neither party could have anticipated or controlled. As a result, both parties were discharged from their obligations under the contract. Taylor and Lewis were not required to pay the agreed-upon rent, and Caldwell and Bishop were not liable for failing to provide the music hall for the concerts. This decision established an important legal principle. It recognized that if an unforeseen event occurs that makes the performance of a contract impossible, the parties may be relieved from their obligations. This principle allows for fairness and flexibility in contractual agreements when unforeseen circumstances arise. In conclusion, the case of Taylor v. Caldwell has had a significant impact on contract law. It emphasized the importance of risk allocation and fairness in contractual agreements, recognizing that parties should bear the risk of events that are beyond their control. It highlighted the flexibility and fairness that the doctrine of frustration of contract brings to the legal system when unforeseen circumstances arise. Hope this discussion has been enlightening and that you've gained a deeper understanding of the principle of frustration of contract through the case of Taylor v. Caldwell. Thank you for watching.